One of the issues that folks have early on in personal injury claims before a lawyer like me gets involved is I've gotten papers from the insurance company. What papers should I sign? Should I give a recorded statement? My answer is if you're going to represent yourself, and there's no law that says you have to have a lawyer, if you're going to represent yourself, then you're probably going to have to give a recorded statement. You're probably going to have to sign the papers that the insurance company sent you to sign, because that's how they get information about your injuries, the accident, and generally just about your claim. Usually the forms that the insurance company sends you that don't relate to property damage are a medical authorization. What they want you to do is sign it, send it back. They can then send it to doctors, hospitals, physical therapy places, and get your records and get your bills. If you're considering a personal injury lawyer, my advice to folks who are in that process, don't give a recorded statement unless you have a lawyer on the line. Not that the adjuster's an evil person, but they're going to ask you questions that they may not have a right to get answers to. They may ask you questions that you provide an honest answer to that you later learn were wrong. Many times when I listen to recorded statements that folks give the day of an accident, the day after an accident, they say, oh, my neck hurts. Then a couple days later, their back starts to hurt. The adjuster says, well, that can't be related to the accident because I took a recorded statement the very next day and your client only mentioned his neck. Well, the reality of personal injury accidents are all of your injuries don't normally present within an hour or 12 hours or 24 hours. Sometimes some of these injuries take some time. Sometimes a low-grade ache in your back can over time develop into a high-grade pain. The point is, when you give a recorded statement, you're committing yourself to certain facts which may be true at the time, but may later turn out not to necessarily be true. Secondly, when you sign a medical authorization, most people just sign it and return it. I advise folks, if you're going to represent yourself, you sign the medical authorization, okay, but at least put in the names of the medical providers to whom that medical authorization can be sent and the conditions for which they're authorized to disclose. So for instance, if you went to see your family doctor for a neck ache, they don't need anything below the waist, do they? Well, if you don't put that limitation in the medical authorization, they're going to get it. The final thing about these medical authorizations, and I learned this, I think, in my first 6 months as an attorney. A lady came to me. She had been representing herself. She had signed a medical authorization, hadn't put in any of the doctors, hadn't put in any sort of limitation to conditions, hadn't put any sort of limitation as to time. And so when I contacted the insurance company and said, I want you to give me a copy of all the records that you got with my client's medical authorization, I literally got a banker's box full of medical records, and about this much actually related to the accident. The rest of the records were gynecological records, childbirth records, psychological records which had nothing at all to do with the accident, other records from various providers that had, that dealt with conditions that had nothing to do with the accident. And my client, I'll never forget this, literally started crying because she realized that this adjuster had been pouring through her entire life, and she had not realized that by signing that authorization, that's what she was allowing herself to do. If you're considering hiring any kind of personal injury lawyer, please don't give a recorded statement. Please don't sign those medical authorizations unless the lawyer advises you to do so.